Tonight we begin with a ruling that constitutional scholars had whispered about in nightmares, dismissed as impossible, and feared more than anything else in modern American history. A decision that did not unfold over years of careful deliberation, but in a single afternoon. One afternoon that ended 248 years of unbroken precedent. One afternoon that turned no president has ever been jailed from fact into memory. One afternoon that forced the executive branch to look straight into the abyss of its own power and blink. What the Supreme Court did at 2:43 p.m. Eastern Time today is something no court, not Marshals, not Taney's, not Warren's, not even Roberts has ever done in the entire constitutional history of this republic. They issued a direct, enforceable order of custodial detention against a sitting president of the United States for criminal contempt, effective in 24 hours unless purged. And the White House was given exactly that long 24 hours to decide whether the president will walk into federal custody or whether the republic itself walks into uncharted fire. For 14 months now, there had been signals, not leaks, not official statements, just signals that the president was preparing something unthinkable. He has always been defiant, yes, but in the last year he became something colder, systematic in his defiance. The pattern was almost ceremonial. Lower court issues gag order. President violates it within hours on Truth Social. Judge issues fine. President laughs it off, fundraises off it. Judge threatens contempt. President dares the system to act. But what set off alarm bells inside the Justice Department this week was that the pattern suddenly went silent. The analysts who track presidential contempt the way NORAD tracks missiles know the indicators. The nightly all-caps posts stopped. The legal team stopped filing extensions. The public taunting of Judge Chuck Kahn ceased, and the sudden, eerie quiet from Mar-a-Lago. All of that went dark Wednesday night. And whenever this White House goes quiet, it means something is about to get very, very loud. Early this morning, the Supreme Court's emergency docket detected what clerks described as an unscheduled shadow docket detonation. At 9:07 a.m., the court on its own motion converted a routine contempt appeal into an original jurisdiction plenary case, something that has not happened since 1793. These are the kinds of procedural nuclear weapons the court only deploys when it is signaling something very specific. We are done waiting. We are done negotiating. We are prepared to enforce. Observers didn't know whether this was a 5-4, 6-3, or 9-0 bomb, only that the building itself seemed to hold its breath. But what they did know was that the Supreme Court was changing posture. And when the nation's highest court shifts posture without explanation, even by a single inch, the entire government pays attention. The order issued by the Supreme Court tonight was not normal. It was not routine. It was not academic. It was biblical. Sources inside the court after the closed conference described the majority's conclusion as unprecedented, unavoidable, and perhaps most importantly, non-negotiable. Because warnings only work if the target believes you will act. The president did not. So the Supreme Court did. And their response today was the most consequential assertion of judicial power since Marbury, maybe since Dred Scott in the opposite direction. Here's what we know. Within 4 hours of receiving the final certified contempt findings from Judge Chuck Kahn, the Supreme Court denied stay, denied certiorari as moot, and issued an original writ of execution. These weren't the usual carefully worded remands. This was a judicial kill shot tools the court has never deployed against a sitting president because no president has ever pushed them this far. Tonight, sources inside 1 First Street confirm that the Supreme Court executed the judicial equivalent of a spec ops raid on presidential immunity itself. They struck before the White House could file its inevitable emergency stay. They hit the court claim, a president cannot be jailed while in office, and vaporized it. They hit the Secret Service protection claim and neutered it. They hit the political question doctrine and buried it. In other words, the court targeted the 3 load-bearing walls that have shielded presidents from accountability since 1789. The component that would have made indefinite defiance operational, gone. This is what made Chief Justice Roberts' separate concurrence so devastating. He wrote, quote, "The framers did not create a monarch clothed in temporary immunity. They created a servant of the law. When that servant becomes its saboteur, the judiciary's duty to intervene is not discretionary, it is existential. That is not rhetoric. That is a declaration of war on unchecked executive power. And here's where the story becomes terrifying. Legal analysts now believe the president's 14-month defiance campaign was designed to probe the breaking point of judicial tolerance after the court's immunity ruling in Trump v. United States seemed to give him running room. He wanted to see whether the Roberts Court would actually enforce its own red lines. But instead, the opposite happened. The court didn't flinch. They escalated so ruthlessly, so precisely, that even the president's own former SG is reportedly speechless. You don't get this White House's attention easily. But today, the Supreme Court did. Anonymous former officials described the majority's reasoning as Jacksonian, a deliberate echo of Andrew Jackson's defiance, except this time the court is saying, John Marshall has made his decision. Now, John Marshall will enforce it. As reports kept pouring in throughout the evening, we learned the true scale of the court's assertion. Justice Sotomayor wrote a separate concurrence laying out the 14 violations in excruciating timestamp detail, turning the opinion into a public indictment. Ness, Kavanaugh refused to join any stay, forcing the conservative bloc to own the outcome. The U.S. Marshal Service was quietly activated under 28 U.S.C. Sething to prepare contingency detention protocols, something never triggered for a sitting president. This wasn't just a ruling. This wasn't just a president. This was judicial regime change. This was the third branch declaring that the era of presidential impunity is over. Remember, every president since Nixon thought the courts would never cross this Rubicon. They thought fines would always be symbolic. They thought jail was always theoretical. They thought the Secret Service would always be a human shield. But tonight, the exact opposite is happening. The court just proved fines can become cuffs. Theory just became practice. And the Secret Service just became a logistics problem. What makes this moment so existential is that the president's defiance campaign began when he was politically strongest, 10 months before midterms, with sky-high approval among his base. The MAGA base wants defiance. Institutional Republicans want survival. The military wants clarity. The world is watching to see if America still has guardrails. And when a leader under this much pressure makes sudden defiant moves, he is not doing it from strength. He is doing it from terror. The White House statement tonight, distributed only by email, no press availability, was designed to signal that the president is not willing to go quietly. Officials said plainly that the Supreme Court's order was illegitimate and unenforceable. That is diplomatic language for, come and take him. You don't usually hear that tone from the White House unless they are prepared to burn the house down with them in it. Meanwhile, the president addressed a hastily assembled crowd on the Mar-a-Lago lawn in a furious, shaking 11-minute speech tonight. He said, "They will have to drag me out in chains." He said, "This is their Reichstag fire." And he said, if they want a war, patriots know where to stand. These are not rhetorical flourishes. These are the words of a man who knows the 24-hour clock is ticking. Here's what makes the situation even more dangerous. The president's latest move wasn't isolated. Along with the defiance, Proud Boys channels are openly organizing protection details. Oath Keepers leadership released a joint statement vowing physical interposition. Multiple Republican lawmakers have already said they will not recognize the order. All of this happened within the same 24-hour window. When this White House moves multiple extremist pieces at once, it means the endgame is here. Analysts are now gaming out 4 scenarios. 1. The president complies, walks into custody, purges contempt, and shatters his movement. 2. He defies and forces a direct confrontation with federal marshals. 3. The cabinet invokes the 25th Amendment overnight, the thing being quietly discussed in Situation Room side chats right now. 4. Parts of the military or Secret Service refuse orders, splintering the chain of command. But today, the Supreme Court took the easy off-ramps away. They didn't negotiate. They didn't delay. They didn't blink. They enforced. What we're watching now is the ultimate test of whether the American constitutional order is still a government of laws and not men. The president wants to see if the system will crack before he does. The Supreme Court wants to show that some lines, once crossed, cannot be uncrossed. The marshals want to avoid bloodshed, and the world wants to know if the American century ends in a parking lot in Palm Beach. Tonight, sources inside the Justice Department say contingency detention sites have been prepared, not named. The Secret Service has been briefed on non-cooperation protocols, And the president's decision to return to Washington has been canceled. He is staying in Florida. But the Supreme Court is not backing down. Their action, today ruthless, unanimous in result, if not in reasoning, and mercilessly clear, sent a message to the White House that the era of exceptions is over, and it sent a message to history that 248 years was long enough. As this 24-hour deadline counts down, we expect more details to emerge about what exactly the president will do when federal marshals arrive. But what we do know is that the Supreme Court's action was timely, it was surgical, and it was final. What happens next will depend on what the president does before 2:43 p.m. tomorrow. If he complies, this moment will be remembered as the day the system held. If he defies, the Supreme Court has already shown they are ready. They have shown they are willing, and they have shown they will not hesitate again. And tonight, for the first time in 248 years, the White House appears to be afraid. Washington is quiet. Too quiet. And when a cornered president is quiet, it means he is calculating. Because tonight, Donald Trump learned something for the very first time. The courts can reach him. The law can bind him. And tomorrow, the Constitution may finally cage him. This story is nowhere near over. But tonight, one thing is clear. The Supreme Court just drew a line in blood. The president is on the wrong side of it. And America is 24 hours away from finding out who blinks first. We will be here when the clock hits 0,